Hi there. Thank you for joining me on this conversation. For those listening to this as a podcast, welcome to our third episode of the series. My name is Ruo, and I'm a Senior Associate at Winckworth Sherwood's Charities and Social Enterprises team. I'm delighted to be joined by my colleague, Chris Garrett, who is a partner in our employment team. Chris, welcome to this podcast.
Thanks, Ruo. Very pleased to be here.
Chris, your webinar, Data Protection, AI in the Workplace, covered some fascinating areas which are both relevant and topical as we see the use of AI develop and expand across various sectors. Now, next month, I will be chairing a discussion at the annual Charity Law Association conference on the application of AI in the charities sector. I will share a link to that upcoming conference in my show notes. Chris, I'm interested in exploring the multifaceted approach of AI, and as noted in your recent webinar, its application in the workplace setting, and some of the legal issues associated with this. I'm keen to learn from you today on the main themes of your webinar. So perhaps if I may start by asking you, what inspired you to give your recent webinar, and could you summarize what the key themes were?
Yeah, sure. AI has been getting a lot of attention over the last few months, and we were beginning to get questions from clients, employers about the legal issues around their employees using publicly available AI tools such as ChatGPT for work purposes, and also, separately, but also related to AI, about the privacy implications of an employer or an organization using AI tools for efficiency or other purposes within their workplace. And we thought a session bringing these topics together would be timely and interesting for our clients and contacts. And I think it's fair to say that a lot of the media coverage we see about AI has led companies to think they need to worry about using AI, but perhaps not really know what it is they should be worrying about. The first area I discussed in the talk was the ways in which AI and automation can be used in the workplace and the benefits for companies in doing so. We also talked about the use of AI and technology for workplace surveillance, so tracking your own employees, which obviously gives rise to some very significant privacy concerns. And then I covered some issues relating to the policies and other considerations that employers should have in place in connection with the use by their employees of things like ChatGPT and other similar generative AI tools that are available available to them.
Yeah, absolutely. So I've been touching just a few bits of what you've said. I mean, all AI tools involves processing of personal data, doesn't it? In your opinion, can that be problematic? And can automated decision-making be problematic specifically?
Yeah, I mean, when it comes to automated decision making, I mean, there are certainly some specific legal issues that need to be addressed, and frankly, they are obstacles that can make AI difficult to use in automated decision making as the law currently stands. So currently, any data subject, including an employee or candidate or anyone about whom you're using data, they have the right not to be subject to decision based solely on automated decision making or automated processing, including profiling, if that decision produces legal effects concerning them, unless one of the exceptions apply. And I think it's important to note that these rules only apply where there is no human intervention in the decision. So AI, which assists a human in making and ultimately making a decision, that's not caught by the rules relating to automated decision making. But if there is no human making the ultimate decision and the employer or the company slavishly follows the outcome of an algorithm, for example, then you're squarely within within these rules. And the exceptions that do allow you to do this, so where you have the express consent of the person, so they know what you're doing, they know why you're using automated decision making, and they've said, yes, I'm happy with that, or where it's necessary for the performance of a a contract, but that's, I think, a relatively limited set of exceptions. And there have been some fines relating to this, not particularly in the UK, but in other European jurisdictions. There have been some quite hefty fines for the use of automated decision making without any human intervention. For example, one of the food delivery companies, Foodinio, was fined well over €2 million in Italy for automated decision making without human intervention that affected its delivery drivers. So there's some significant risks in sort of pushing ahead with automated decision making, even for companies where there's an obvious business efficiency to using that.
Yeah, absolutely. And one aspect of your talk that I thought was quite fascinating is touching on discrimination in recruitment. And I recall you provided an example where if you were to use one of the AI tools in profiling and the person didn't get the initial interview is because due to a disability, then, as we know, the laws in this country, underpinned by UK GDPR and data protection rules, means that employers need to make reasonable adjustments. So could you talk a little bit about that aspect and the problems that could cause?
Yeah, absolutely. I mean, yes, I mean, it's a real area of crossover between discrimination law and data protection, and AI tools are increasingly used in recruitment. I mean, we've seen, for example, companies who use sort of simulated gaming systems to sort of test the abilities of their candidates for employment. And what they generally do in those tools is they will have had their sort of high achieving employees play the games to set and sort of identify the key characteristics of high achievers within the organization. Then they'll give the same game to candidates who will be invited to play the game, and those sort of showing the same characteristics as the existing high achievers may go through to the next stage of the recruitment process. And obviously that can in some circumstances just entrench an existing bias within an organization. So if the existing high achievers are from a pool that's been sort of tainted by bias originally, then the identification of the successful candidates is also going to be tainted by the same bias, and that could give rise to discrimination claims.
Yeah, absolutely. And given the potential discrimination claims and some of the other pitfalls that could arise, like the Italian case that you mentioned, so what can we do? I mean, what are we doing to support clients in this space?
So, I mean, we get asked a variety of different questions. I mean, I suppose AI is a massive topic, and it spans various different areas. I mean, one of the main areas we're supporting our clients is the sort of the drafting of policies for the use of things like ChatGPT, and I think to have an effective policy in that area, you first really need to identify what the risks that you're facing through your employees using ChatGPT are. I mean, coming back to your question more specifically on sort of how to avoid the discrimination risks, then I think the key in the recruitment is that you're not making any final decisions or ruling anyone out without the opportunity for human intervention, and that ought to identify, if done properly, where somebody requires a reasonable adjustment as part of the recruitment process. So if you've asked the question, which even if you're not using AI in your recruitment, you probably will be asking the question about whether the candidate considers themselves to have a disability for the purposes of the Equality Act. And if you've asked that question, you've got the answer, then you ought to have the tools to allow you to make reasonable adjustments. And then separately, the outcome of those gaming exercises, that shouldn't be the final decision making. It can play a part in the recruitment decision-making process, but it oughtn't be the deciding factor. And that those two kind of approaches ought to protect employers from the most obvious discrimination risks. And if your process is tainted by bias because it's sort of modelled on your existing workforce, then really that's more of a problem for the effectiveness of the recruitment, and you're not really getting the best people. You're missing out, frankly, on potentially sort of very effective candidates for employment if they're being weeded out through a sort of biased process.
Yeah, and do you consider the need of having a data protection impact assessment as being necessary, and a privacy notice perhaps as well?
Yep, absolutely. I think for anything that's touching on automated decision making or profiling of individuals, then you certainly need a data protection impact assessment, and that's really a process which allows you to consider the impact on the privacy of individuals through the processing of their personal data that you're carrying out, and to identify whether there are any less intrusive ways of achieving what you're looking at doing, and if there are, sort of exploring whether those could be implemented rather than the original proposal. So that's definitely even if it's not legally required, it's still a good practice step to have gone through, to have identified those risks and possible mitigations.
Yeah.
And indeed, in some cases, to identify whether the risks outweigh the benefit, and you shouldn't be going ahead with that. It would also help you identify whether you're using sort of special category data, which can be relevant here. So biometric data, for example, could be special category data, or AI tools that analyze the tone of a meeting or a person's sort of approach through the use of facial recognition or similar technology. That could be something that your DPIA will flush out, particularly if that's the first time that your data protection officer, for example, has been involved in a new tool that you're planning to use.
Yeah.
And then privacy notices absolutely sort of bread and butter of any sort of data protection professionals of life. The privacy notice ought to properly explain and clearly explain to people how their personal data is being used. I think that also requires you to explain how you're using artificial intelligence in the processing of people's personal data. I've been doing that with several clients over the last few months. Even simple tools like the Microsoft tool that can generate a summary of a meeting using Microsoft Teams, where you have the record and transcribe function enabled. There's an additional tool that can create a summary of the meeting, or can analyze the tone of the meeting, and that ought to be explained in the privacy notice that you're giving to people whose data you're processing in those meetings.
Yeah, and what I found interesting in your webinar was you asked ChatGPT to prepare, I think, a privacy notice. You gave it a simple exercise to do, and it'd be interesting for you to share your thoughts on what the ChatGPT results were and the pitfalls on that. And I guess linked to that, what do you foresee as being the opportunities and threats in the use of AI?
Yeah, sure. I mean, I think I should note that I did that as an exercise purely out of interest for the webinar, rather than anything I produce for my clients. But I think if you know what you're doing in that kind of exercise, then ChatGPT and similar tools can get you probably 90% of the way. It can give you a very good first draft. I found, the document that it produced for me when I asked it to draft a privacy notice, it looked like a privacy notice. It covered most of the areas that were required by GDPR. There were a few things that were missing, and there were a few things that I knew, because this is what I do for my day job, had been drawn from the requirements of other legislation. So it had obviously drawn in things from privacy notices of companies outside the EU, and had included those in the suggested document. But because, if you're an expert in what you're doing, you know how to identify those things, then absolutely a totally sensible thing to be using to produce your work. But the danger for companies is sort of junior or unskilled employees, or people who are sort of maybe working on something for the first time or outside their usual area of expertise, because what it produces, it looks quite convincing. There can be an assumption that it's correct, and sort of quality control, certainly at the moment, is definitely a big issue that employees should be worried about. Depends, of course, a bit on how important it is to be 100% accurate. If you're a lawyer producing legal advice, it's very important. If you're writing a speech or a webinar, for example, then maybe it's slightly less important. And I think that's part of what a good policy in this area can tell you. It can help you do a risk assessment of when it's risky to be using AI tools and when it's less risky. I mean, there are other issues with using it. I think the one that concerns us most as data protection lawyers is if you inadvertently or deliberately include personal data in what you ask ChatGPT, then you could be breaching the law in doing that, because the terms of use of ChatGPT make it clear that it's not necessarily just going to be used for producing what is then sent, given back to you. Equally, the same applies for confidential information. And there are some IP issues which I think still really to be flushed out about, sort of who really owns the output of a ChatGPT inquiry that's done by an employee of a company. So those are. But I think probably these are teething problems, and these are things which will be, in 5 or 10 years' time, we'll probably look back and wonder why we were worrying about these issues. And I think, I certainly think generative AI, large language models, that's going to be a major factor in our working lives in the years to come. So it's here to stay. Obviously, we need to work through these issues, and we're here to help our clients do that.
Yeah, absolutely. And I think you nicely sort of summed up that human intervention at this point in time is still very necessary. As we've seen, some of the common critiques of certainly generative AI is obviously the data sets. Is it biased? Is it reliable? There's issues about misinformation and possibly even disinformation. And we've seen cases, certainly in the US, where lawyers have been sued for over-reliance on the data generated by ChatGPT, which has turned out to be untrue, of false information. So there's clearly risks in that regard. And I think human intervention is definitely necessary, because I think transparency is, when you agree, transparency is still an issue, because not a lot of people, myself included, understand just exactly what the black box of AI is. We can see the data getting trained, and we see the information that's generated, but what goes on in that middle piece, I don't know what the answer is, quite frankly. So I think that bit remains to be seen. And did you have any particular thoughts about sort of the wider legislation landscape? Because I know in the UK, the white paper that we had is very much pro-innovation, and there doesn't seem to be any sort of new laws like we see in the EU Act, to regulate this area. Although I noticed last month the there was an update in the National Risk Register where the UK government flagged that AI, was seen as a chronic risk in its National Risk Register. So I wondered what your thoughts were just on that larger, wider regulatory landscape.
Yeah, it's an interesting question, and as you say, there are various different jurisdictions that are taking different approaches, and we see legislation in the US, the EU, possibly in the UK, and as you say, I think the UK is at least attempting to present itself as pro-innovation and a deregulatory state, certainly as compared to the EU. I'm not sure that's really sort of sustainable for us to maintain huge differences in our laws with our closest trading partners. There are many companies that operate, of course, in the EU and in the UK. So for those, it's frankly somewhat unhelpful for the laws to diverge too much, because it just it limits the extent to which you can benefit from a sort of pro-innovation regime in the UK. I mean, I think there are certainly some threats from the use of AI. I'm not totally sure how they can really be countered by legislation. I'm thinking, there's been quite a bit in the press recently about the use by cyber criminals of AI, and it's sort of giving them the tools to conduct cybercrime, which maybe, unless they were sort of, skilled in the area, they previously would have sort of had trouble accessing. Now, generative AI can teach you how to commit your cybercrime, but equally, the other side of the coin is that AI tools allow those who are defending against cybercrime much greater capability as well. So it's sort of the game of whack-a-mole sort of has with higher stakes, frankly now, and it's an interesting microcosm of the risk and reward of AI. So I suppose another risk that people see in AI, more of a societal one, is displacing people from their roles, and I think obviously that's not going to be something that any piece of legislation is going to deal with, and it's one of the unknowns, I think, is whether AI will lead to higher unemployment because it will replace more administrative roles, or perhaps, looking on the more positive side, it'll release people from the shackles of more mundane work and allow them to concentrate on more productive tasks. So I think it's definitely a case of watch this space. It will no doubt have some impact on the workforce and the kind of roles that people are needed for. But certainly is not something that, as I said a moment ago, it's not something that's going to go away. So that I think any company needs to embrace, and the workforce needs to embrace it as well.
Yeah, absolutely. And I get a sense from looking at the literature, wider literature, that it's because of this very sort of ever-changing landscape of AI that it's hard for the UK government to sort of start compiling a piece of legislation. I think they're using watch this space to look and see what's going on, and to, at the moment, place responsibilities on the existing regulatory bodies to sort of police the development of AI. But it's interesting to see the work of the AI Standards Hub, and I know the Alan Turing Institute recently had a podcast on the regulatory landscape of AI. So I do recommend for those that haven't listened to that, to check that particular podcast out as well. So at the time of this recording, certainly, and I attended recently a meeting with somebody from the Charity Commission, And we touched on sort of AI very briefly toward the end of a discussion on a separate matter. And what I've seen from sort of what they've said on the AI piece is that they're certainly very conscious of AI. They are keeping a close watch on the AI, but as of yet, they are not going to provide any written guidance on charities and AI. So for those listening who work in the charity sector, the CC26 guidance, charities and risk management, would be a good starting point to review some of the new and emerging risks, AI included. So it's useful to sort of be familiar with that guidance. So on that note, Chris, thank you for your time. And for those listening and those interested on the application of AI in the charity space, please do take a look out for my upcoming conference next month. And thank you once again for those watching and for those listening to this as a podcast. I hope you found our conversation inspiring and informative. And I hope to catch you in our next episode. Bye.